Now let's talk more about the disciplinary process.
Hi, I'm Marcia Kazarosian, and I'm a partner in the firm of Kazarosian Costello. I was appointed to the Post Commission in 2021 and have served as its secretary since my appointment. As a trial attorney since 1982, I bring an eclectic perspective to the commission. I've represented criminal defendants in the state and federal courts, and also plaintiffs in civil rights matters, among other areas of law. I currently also serve on the SJC's Clerk's Ethical Opinion Committee, and I'm a past president of the Massachusetts Bar Association, the Massachusetts Academy of Trial Attorneys, and the Essex County Bar Association. In Module 3, we will go over aspects of the disciplinary process, including information that's required to be submitted to post, such as complaints and reports, and the procedure for the complaint intake from both law enforcement agencies and the public. We will define what a complaint is and describe what action is taken following post's receipt of a complaint, and we will also discuss preliminary inquiries, prohibited conduct, such as chokeholds, and the adjudicatory process. And finally, we will discuss the public data that Post releases, which will include sustained historical disciplinary records of all active officers. This is an important part of our efforts to increase transparency and public confidence in law enforcement. Thank you for listening. Let's begin Module 3.
In Module 3, we will discuss the types of complaints that need to be submitted to post, actions taken following complaint submissions, and disciplinary actions like suspensions, preliminary inquiries, and hearings. Now we're going to take a look at information that is due to post, meaning complaints and other reports, as well as actions that agencies are required to take following receipt and submission of the complaints. First, law enforcement agencies are required to submit credible complaints alleging misconduct by an officer to post within 2 business days. Complaints can originate from a member of the public, from personnel at the agency, or from any other source. Reports of incidents that involve excessive force, officer-involved shooting, or events that resulted in serious bodily injury or death are automatically due to post, even if an official complaint was not made. This process is governed by statute. For additional guidance on this topic, please visit the Post website. Following receipt of a complaint, law enforcement agencies must investigate the complaint and submit the results of the internal affairs investigation to post within 90 days, along with their findings and any discipline that was imposed. The head of the agency may recommend post take certain action up to and including decertification. In the event of appeal or reversal, an update must be submitted to post. It is important to note that if the officer resigns to avoid discipline, the internal affairs report still needs to be completed and forwarded to post, and both the agency and post may take subsequent action. Now let's take a look at suspensions and the different types. Officers can be given different kinds of suspension by post, including a mandatory immediate suspension, a mandatory administrative suspension, or a discretionary suspension. First, we will discuss mandatory immediate suspension, which relates to officers involved in felony proceedings, those arrested, indicted, or charged with a felony, and those that have engaged in conduct that could constitute a felony. As mentioned, the Commission immediately suspends the certification of an officer who is arrested, charged, or indicted for a felony. Officers may request a hearing before a single commissioner. If charges are dropped or reduced, the officer may request for the suspension to be lifted. Note that terms of employment of the officer remain subject to Chapter 31 and any applicable collective bargaining agreement. Next, we'll talk about administrative suspensions, which are also mandatory and immediate. These usually happen when an officer fails to complete in-service training or fails to report certain information to post. To reiterate, the Commission administratively suspends the certification of an officer who fails to complete in-service training within 90 days of the imposed deadline. Post may grant a timeline exception to officers for injury or physical disability, leave of absence, or other documented hardship. Once the officer completes the training requirement, their certification is reinstated. And an officer may also face administrative suspension for failure to submit certain reports due to post. Now let's discuss when the Commission can implement discretionary suspensions. Discretionary suspensions stem from 4 different reasons, which are a misdemeanor conviction, bias, pattern of unprofessionalism, agency discipline, or repeated sustained complaints. The second type is a misdemeanor proceeding. Third type is if the suspension is in the interest of the public welfare. And lastly, a mandatory suspension where a hearing is suspended due to a criminal case. Discretionary suspensions occur only after a hearing is held. The Commission, after the hearing, may suspend the certification of an officer based on a misdemeanor conviction, or if the Commission determines by a preponderance of the evidence that a crime affects the fitness of the officer to serve as a law enforcement officer, and suspension or revocation hearing shall not begin until an appointing agency has issued its finding or 1 year has elapsed, whichever is sooner. The Commission may suspend the certification of an officer if the Commission determines by a preponderance of the evidence that it is in the best interest of the health, safety, or welfare of the public. Post does not have to wait for an agency investigation. There is an opportunity to schedule a hearing before a single commissioner. Now we're going to talk about some of the aspects of preliminary inquiries into officers. A preliminary inquiry is the term used in Chapter 6E to refer to the investigatory process that the Division of Standards undertakes when investigating allegations of misconduct or prohibited conduct by a law enforcement officer. All proceedings and records pertaining to a preliminary inquiry shall be confidential, except that the Executive Director may turn over to the Attorney General, U.S. Attorney, or District Attorney evidence that may be used in a criminal proceeding. If the Commission or Division of Standards receives a complaint, report, or other credible evidence that is deemed sufficient by the Commission, the Division of Standards initiates a preliminary inquiry. There are 3 types of preliminary inquiries as noted here. When the Division of Standards ascertains that there is a complaint, report, or other credible evidence where an officer was involved in an officer-involved injury or death, committed a felony or misdemeanor, whether the officer has been arrested, indicted, charged, or convicted, or engaged in prohibited conduct, the Division will go to the Commission to seek approval to initiate a preliminary inquiry. The Commission receives an affirmative recommendation by the head of an appointing agency for disciplinary action by the Commission, including retraining or suspension or revocation of the officer's certification. As per Chapter 6E, Section 14, the listed tactics are considered prohibited conduct unless an officer or agency has used de-escalation tactics and/or those tactics are not feasible based on the totality of circumstances and are necessary to prevent imminent harm. Prohibited conduct includes excessive physical force without attempts to de-escalate, deadly force without attempts to de-escalate, chokeholds, discharges of a firearm into a fleeing vehicle, and certain tactics on mass demonstrations, tear gas, rubber pellets, and dogs. The use of force regulations state that to comply with the requirements to de-escalate before using deadly force, officers should attempt as many de-escalation tactics as feasible. The Commission understands that officers encounter situations that can change very quickly, and as per the statute, they will be analyzed based on the totality of circumstances. Per Chapter 6E, Section 15, an officer present and observing another officer using physical force, including deadly force, beyond that which is necessary or objectively reasonable based on the totality of the circumstances, shall intervene to prevent the use of unreasonable force unless intervening would result in imminent harm to the officer or another identifiable individual. An officer who observes the above shall report it to a supervisor no later than the end of the shift. Agencies shall implement procedures for officers to report abuse by other officers without fear of retaliation or actual retaliation. A preliminary inquiry is discretionary if the officer engaged in possible prohibited conduct, or if upon identification of a pattern of unprofessional police conduct under the statute. Prohibited conduct as outlined in Chapter 6E, Section 8C2 and Section 8F. Section 8C2 allows the Division of Standards to initiate a preliminary inquiry if there is sufficient credible evidence of prohibited conduct. Prohibited conduct is construed to include all prohibited conduct described in Chapter 6E, and lastly, Section 8F directs the Division of Standards to monitor the database to identify patterns of unprofessional police conduct. Although the practices and conduct described in this slide have been previously prohibited by law enforcement agencies, the statute directed the Commission to, after a hearing, revoke the certification of an officer if the Commission finds by clear and convincing evidence that the officer has engaged in the conduct summarized here. All proceedings and recordings related to a preliminary inquiry or initial staff review used to determine whether to initiate an inquiry shall be confidential. The Division of Standards shall notify any law enforcement officer who is the subject of the preliminary inquiry, the head of their collective bargaining unit, and the head of their appointing agency of the existence of such an inquiry and the general nature of the alleged violation within 30 days of the commencement of the inquiry. The Commission may suspend the certification of an officer as part of a preliminary inquiry. Also, after the preliminary inquiry, the Commission may vote to initiate adjudicatory proceedings, which can lead to an adjudicatory hearing. Now let's talk about the process for hearings. In this graphic, we outline the adjudicatory process for denials of full recertification. And here you'll see the 7-step process, starting with the denial of full recertification. That's when the Division of Police Certification provides notice of the decision to deny full recertification to an applicant, agency, and collective bargaining unit. Then the petition for review. That's when the applicant petitions the executive director for review within 21 days of the Division of Certification's decision and sends that petition to the agency. Executive director review. This meeting is at the discretion of the executive director, and that's when the executive director issues a decision to the applicant and the agency within a reasonable time. Request for a hearing. Applicant has 30 days after the executive director's determination to file a request for a hearing before the full commission. Chair of the commission may also assign hearing officer to preside over the hearing. Then we have the pre-hearing in step 5. That is when the parties confer on resolution, discovery, stipulations, and other matters in preparation for the pre-hearing. And parties attend pre-hearing conference conducted by the presiding officer. Hearing happens for the full commission or hearing officer presides over the hearing, and the applicant can receive a transcript at their own expense. Lastly, the hearing officer's final decision is tentative, subject to objections by the applicant. The full commission determination is final, and the applicant has 30 days to appeal the final decision to the Superior Court. Now let's go over the adjudicatory process for mandatory suspensions as outlined here in a 5-step process. Imposition of suspension. That can happen with or without a preliminary inquiry. Without a preliminary inquiry, administrative suspensions can be issued by the executive director for failing to complete in-service training and failing to report alleged misconduct. Non-administrative suspensions by the executive director can happen if an officer is arrested, charged, or indicted for a felony. After a preliminary inquiry, non-administrative suspensions by recommendation of the Division of Standards and by vote of the Commission can happen for engaging in conduct that could constitute a felony. Next, we have the request for hearing to stay suspension. Within 5 days of notice of suspension, the officer may file a hearing request with the executive director to challenge the immediacy of suspension and can waive the 15-day hearing requirement, or the officer may request more time for the hearing. An executive director must schedule the hearing within 5 to 15 days after the effective date if time standards have not been waived, and notify the officer and chair of the commission. Next, we have single commissioner review. That is when the chair of the commission assigns a single commissioner within 2 days of receiving a hearing date from the executive director. The single commissioner may stay the immediate suspension of the officer's certification. The single commissioner's decision on whether to stay suspension is final as to that commissioner. The officer may appeal a single commissioner's decision not to stay suspension to the Superior Court. The request to lift suspension happens when the officer may request the commission lift suspension. That's if the executive director receives requests as to suspensions for failing to complete in-service training or reporting certain alleged misconduct, if the full commission has not issued a final decision. There is no time limit on when the officer can request to lift that suspension. Finally, we have the disposition, which is the executive director must reinstate administratively suspended certification after completion of in-service training or reporting information in lieu of a hearing. Otherwise, the suspension orders remain in effect until the commission issues a final decision or until the commission revokes a suspension. This graphic outlines the adjudicatory process for non-mandatory suspensions. It's a 5-step process. Starting with the imposition of suspension, after a preliminary inquiry, suspensions by the commission can happen for arrest, charge, or indictment for a misdemeanor. Pending or after preliminary inquiry, suspensions can happen by the commission if they are deemed to be in the best interest of health, safety, or welfare of the public. Step 2, request for hearing to stay suspension. Within 5 days of notice of the suspension, officer may file a hearing request with the executive director to challenge the immediacy of suspension and can waive the 15-day hearing requirement, or the officer may request more time to request the hearing. An executive director must schedule the hearing within 5 to 15 days after the effective date if time standards have not been waived, and notify the officer and chair of the commission. Single commissioner reviews. That's when a chair assigns the single commissioner within 2 days of receiving a hearing date from the executive director. The single commissioner may stay the immediate suspension of the officer's certification. The single commissioner's decision on whether to stay suspension is final as to that commissioner. The officer may appeal a single commissioner's decision not to stay suspension to the Superior Court. The request to lift suspension can happen when the officer may request the commission lift suspension for the full commission if they have not issued the final decision. There is no time limit on when the officer can request to lift a suspension. And then finally, we have the disposition. That is when suspension orders remain in effect until the commission issues a final decision or until the commission revokes suspension. The Commission may conduct hearings to issue findings, impart discipline, order retraining, or condition, limit, or revoke the certification of an officer. The Commission will not initiate revocation proceedings until a law enforcement agency has issued a final disposition or a year has passed, whichever is sooner. The agency or officer may ask the Commission for additional time to complete the process. The Commission may grant that request, and if not, Commission's action would take precedence. Hearings are presumed to be public, but part or all of the hearing may be closed at the discretion of the Commission chair. After the hearing, the Commission will consider all evidence submitted as part of the record, deliberate, and issue a written determination. Here we will outline the adjudicatory process for matters involving preliminary inquiries. It's a 6-step process, starting with a Commission vote. Commission votes within 30 days of receiving a report from the Division of Police Standards on whether to initiate adjudicatory proceedings. The Commission's decision is effective upon receipt of the decision by officer or head of agency, whichever occurs first. The order to show cause happens next. That's when the Commission issues the officer order to show cause why action approved by vote of the Commission should not be taken against the officer. And then there's time to answer the hearing request. The officer has 21 days to file an answer to the order to show cause with Commission's hearing administrator and serve a copy of the answer to the Division of Standards. Officer's failure to answer may result in default and issuance of a final Commission decision on allegations in order to show cause. The chair of the Commission shall assign presiding officer for the hearing. In the pre-hearing step, parties confer on resolution, discovery, stipulations, and other matters in preparation for the hearing. Parties attend the pre-hearing conference conducted by the presiding officer. Next, step 5 is the hearing. That's the full Commission or a hearing officer presides over the hearing. If an officer wishes to suspend revocation or suspension hearing pending arbitration or appeal of agency's final disposition, the Commission shall suspend the hearing. The applicant can receive transcript at their own expense. And lastly, in the final decision phase, the hearing officer's decision is tentative and subject to objections by the officer. The Commission can suspend or revoke certification or order retraining for criminal convictions, unfitness and danger, fraud, misconduct, bias, agency-imposed discipline, a pattern of unprofessionalism, and sustained internal affairs complaints. The full Commission determination is final. The officer has 30 days to appeal the final decision to the Superior Court. Now, to wrap up this module, we're going to discuss the Historical Disciplinary Records Public Database. Post is required by law to make public certain officer misconduct information through a public database. The database, which has been launched, contains only sustained complaints. It will not include unsustained or unfounded complaints. The process by which we release this data is governed by 555 CMR